This is part 34. We have started discussing offenses affecting the human body, and in the last part we dealt with kidnapping and abduction, and in this part we shall be dealing with sexual offenses as far as offenses affecting the human body is concerned. And here we will deal with offense of rape defined by section 375 of the Indian Penal Code, and then offense, unnatural offense, which is defined by section 377 of the Indian Penal Code, and that will be the last topic as far as offenses affecting human body is concerned, with which we started discussing right from section 299, and today we shall be ending up by coming up to section 377. Now let me, first of all, before I start discussing section 375 of the Indian Penal Code, finish with the section 377, which is what is known as an unnatural offense. And what it says: whoever voluntarily has a carnal intercourse against the order of a nature with any man, woman, or animal shall be punished with imprisonment for life, or with imprisonment of either description for term, which may extend to 10 years, and shall also be liable to fine. Explanation to the section says, penetration is sufficient to constitute the carnal intercourse necessary to the offense described in this section. So this is, if there is sexual intercourse which is against the order of, carnal intercourse which is against the order of the nature, like homosexuality, and much debate has been going on, or the section has been challenged as in the Supreme Court also, and now we are waiting for the decision. But at present we have such a provision, namely, if there is intercourse, carnal intercourse against the order of nature, that is made punishable as far as section 377 of the Indian Penal Code is concerned. With this, now we proceed to section 375 of the Indian Penal Code. Now, with respect to section 377, at present, if there is a carnal intercourse against the order of the nature, that is made punishable. But then, as I told you, waiting for the decision, much discussion is going on, as a result of which, one day or the other, there may be, some decision, and the law will be settled as far as section 377 is concerned. But today, if the decision is given by the Supreme Court, that becomes law of the land. If the decision is given by the High Court, that becomes law of the state, and hence, for the time being, we go by as far as section 377 of the Indian Penal Code is concerned. With this, now we start discussing section 375 of the Indian Penal Code, which defines the offense of rape, and it says a man is said to commit rape when a man is said to commit rape who, except in a case hereinafter accepted, has sexual intercourse with a woman under circumstances falling under any of the 6 following descriptions. So if there is a sexual intercourse as per any one of the 6 descriptions which are enumerated, then that will amount to the offense of rape as defined by section 375 of the Indian Penal Code. And what it says: if it is against her will, she is not ready and willing, but the force has been used by the person, and which as a result of which he had a sexual intercourse with her. But then, in order to understand sexual intercourse, this is the time for us to refer to explanation 2, which says penetration is sufficient to constitute the sexual intercourse necessary to the offense of rape. Generally, when we talk about sexual intercourse, that is always completed by emission of semen, maybe hymen also.
But in order to constitute liability, if a man has inserted his private parts into that of woman, then this is penetration, which is sufficient to constitute the sexual intercourse necessary to the offense of rape as per the explanation.
And then if the sexual intercourse is against her will, that will amount to the offense of rape. If it is without her consent, now what do you mean by without her consent? Now this is the time for you to refresh your memory as far as section 90 of the Indian Penal Code is concerned, in order to understand section 375. Because what it says, a consent is not a consent as is intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. Then it says, if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and the consequence of that to which he gives his consent. And then it says, unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. We will have reference to this when we deal with sixth ingredient as far as this section is section 375 is concerned. But otherwise, if it is without her consent, that will amount to the offense of rape. And then it is the least time. It's not exhaustive but enumerative. For example, if you read thirdly it says, with her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of death or hurt. This is exactly putting a person in fear of injury. This has got reference to section 90. So that is the list. It is illustrative to explain as to when there can be sexual intercourse without the consent. Otherwise, second ingredient includes third ingredient also without her consent. But it says with her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of death or hurt. Fourthly, it says with her consent. It says with her consent. So there is no element with her. Why wording with her consent has been used? Because there is no element of force. She is ready. There is no resistance on her part, and that is the reason it says with her consent. When the man knows that he is not her husband, and that her consent is given because she believes that he is another man to whom she is, or believes herself to be lawfully married. So this is exactly, this may happen in case of a mock marriage, with which we shall be dealing when we start discussing right from section 493 up to 498. There we will come across this mock marriage. With her consent, when the man knows that he is not her husband, and that her consent is given because she believes that he is another man to whom she is or believe herself to be married. Actually, in fact, the marriage has not taken place. Maybe because it is a mock marriage, or she makes her to believe accordingly, and this is exactly you obtain a consent by because of the misconception of the fact, and hence this also will come under without her consent. Fifthly, it says with her consent. When at the time of giving such consent, by reason of unsoundness of mind or intoxication or the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and the consequences of that to which she gives consent. This is again without her consent, because this is the consent given by a person who is intoxicated, or the consent which is given by a person who is a person of unsound mind, or it is given when because of there is administration by him personally or through another any stupefying or unwholesome substance, she is unable to understand the nature and the consequence of that to which she gives her consent. And lastly, it says with or without her consent when she is under 16 years of age. So now here general age, if you have reference to section 90 with which you are dealt, unless the contrary appears in the context consent given by a person who is under 12 years of age, that is a general age, but this is contrary with or without her consent. In other words, if the consent is given by a woman, consent is given by a girl when she is under 16 years of age, her consent is not valid consent, and that will amount, there may not be resistance, there may not be opposition for that But then I mind, well, this will not amount, this will amount to the offence of rape, because when the consent, as far as section 375 is concerned, it says with or without her consent when she is under 16 years of age. As far as section 375 sixth ingredient is concerned. So if the sexual intercourse if it is by any one of the 6 descriptions, ways which are described, then that will amount to the offence of rape as defined by section 375 of the Indian Penal Code. And what is the exception? Exception says sexual intercourse by a man with his own wife, the wife not being under 15 years of age, is not a rape. So, I mean, as we were discussing, can a man be convicted for the offence of theft with respect to his own property? Now, can a man be convicted for offence of rape with respect to his own wife? And the sexual intercourse, it says, by a man with his wife, the wife not being under 15 years of age is not age. In other words, if she is below 15 years of age, that will amount to the offence of rape. But if she is not being under 15 years of age, in that case, in this context, I mean, this is the time, just I mean, not from the point of view of understanding general law, that there is, I mean, a debate which is going on as far as marital rape is concerned, which is under consideration. The husband, if he has got sexual intercourse with wife without her consent, that should be treated as a rape. But yet, I mean, that has not been, I mean, we don't have such a law to this effect, but just by way of information. That's why in the context of exception to section 375 of the Indian Penal Code. Now, this is a time, generally I don't deal with the sections dealing with punishment, but let me tell you, in the past we had, up to 1983, we had 2 sections, namely section 375 of the Indian Penal Code defined the offence of rape, and section 376 laid down punishment for the same. Now we have dealt with section 375, no doubt about it. But then let me tell you, after Mathura's case, which took place in the state of Maharashtra, where a girl was raped in the police station, and then she was raped in the police station by constables. They were acquitted by the session judge. The judgment of the session judge was reversed by the High Court, and they were convicted for the offence of rape. And again the same decision was reversed by the Supreme Court. Because of that decision, there was hue and cry regarding law relating to rape, and hence drastic changes were brought about as far as the law relating to rape is concerned. Because when you talk about law, what we have learned so far, law is an instrument of social change. Law is an instrument of social transformation. Law is an instrument of social engineering. Law must be dynamic. It cannot be static. And then there were many changes which have taken place after that. And now the law which we read as far as the law relating to rape is concerned is what is the amendment to the Indian Penal Code in the year 1983. First part, definition with which you are dealt. Yes, no doubt about it. But now after definition, we have section like 376 subclause 1 and subclause 2 deal with the punishment. And then as this is interesting as a result of which, you will understand the offence of rape only when you read section 375, no doubt about it. But when we start reading subclause 1, it says punishment for rape. And what is it? It says whoever, except in a cases provided for by subsection 2, commits rape shall be punished with imprisonment of either description for term which shall not be less than 7 years, but which may be for life, or for a term which may extend to 10 years, and shall also be liable to fine, unless the woman raped is his own wife and she is not under 12 years of age, in which case he shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. Further part says, provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 7 years. So the minimum sentence that is required to be inflicted by the court of law is 7 years, Generally, when we are dealing with the sections dealing with punishment, we are learned it is the maximum punishment that is laid down. Minimum punishment is entirely at the discretion of the court of law. But here there is, I mean, as far as section 376 subclause 1 is concerned, exception if the court wants to provide it, that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 7 years. This is as far as subclause 1 is concerned. Subclause 2 says, whoever being of police officer commits rape within the limits of police station to which he is appointed, or in the premises of any station house, whether or not situated in the police station to which he is appointed, or on a woman in his custody or in the custody of a police officer subordinate to him, or B says, being a public servant takes advantage of his official position and commits rape on a woman in his custody as such public servant or in the custody of public servant subordinate to him, or C, being on the management or on the staff of a jail, a remand home or other place of custody established by or under any law for the timing in force, or of a woman's or children's institution, takes advantage of his official position and commits rape on any inmate of such jail, remand home, place or institution, or D, being on the management or on the staff of hospital, takes advantage of his official position and commits rape on a woman in that hospital, or E, commits rape on a woman knowing her to be pregnant, or F, commits a rape on a woman when she is under 12 years of age, or commits a gang rape, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may be for life, and shall also be liable to fine, and provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment of either description for a term of less than 10 years. So that is as far as section subclause 2 of section 376 is concerned. Now explanation 1 deals with where a woman is raped by one or more in a group of persons acting in furtherance of their common intention. Each of the persons shall be deemed to have committed gang rape within the meaning of this subsection. Explanation 2 says, women's or children's institution means an institution, whether called an orphanage or home for neglected women, for children or widows' home, or by any other name which is established and maintained for the reception and care of women or children. Explanation 3 says, hospital means the precinct of hospital and includes the precincts of any institution for the reception and treatment of persons during convulsions or of persons requiring medical attention or rehabilitation. With this now, it's very interesting. As I told you, law has undergone a change. After section 376, we have four subclauses. Section 376 capital A, section 376 capital B, section 376 capital C, and section 376 capital D, where intercourse itself is made punishable. And if you start reading section 376 capital A, it says, whoever has sexual intercourse with his own wife, who is living separately from him under a decree of separation, under any custom or usage without her consent, shall be punished with imprisonment of either description for term which may extend to 2 years, and shall also be liable to fine. That is as far as capital A, as far as section 376 is concerned. Capital B deals with intercourse by public servant with woman in his custody, and it says whoever being a public servant takes advantage of his official position and induces or seduces any woman who in his custody as such public servant or in the custody of a public servant subordinate to him to have a sexual intercourse with him, as such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for term which may extend to 5 years and shall also be liable. Intercourse itself is made punishable. 376C, intercourse by superintendent of jail, remand home, etc. And it says whoever being the superintendent or manager of a jail, remand home or other place of custody established by or under any law for the timing in concern or of a woman's or children's institution takes advantage of his official position and induces or seduces any female inmate of the jail, remand home, place or institution to have sexual intercourse with him. Such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for term which may extend to 5 years and shall also be liable to fine. Explanation 1 says superintendent in relation to a jail, remand home or other place of custody or a woman's or children's institution includes a person holding any other office in such jail, remand home or place or institution by virtue of which he can exercise any authority or control over its inmates. Explanation 2. The expression women's or children's institution shall have the same meaning as in explanation 2 to subsection 2 of section 376. And then section 376 capital D, intercourse by any member of the management or staff of a hospital with any woman in that hospital. And it says whoever being on the management of a hospital or being on the staff of hospital takes advantage of his position and has sexual intercourse with any woman in that hospital, such sexual intercourse not amounting to the offence of rape shall be punished with imprisonment of either description for term which may extend to 5 years and shall also be liable to fine. The expression hospital shall have the same meaning as in explanation 3 to subsection 2 of section 376 of the Indian Penal Code. So this is as far as law relating to rape is concerned. But then as a student of law, when you start learning this, as this has undergone a change that I told you, that this was amendment to the Indian Penal Code in the year 1983. Accordingly now, it's not only there is change as far as the Indian Penal Code is concerned, but if you have a reference to section 114 of the Indian 114A of the Indian Evidence Act. Now we had reference to this in the past as far as section 113A is concerned, 113B is concerned. Now this is the time for me to draw your attention that there was an amendment in the year 1984 with respect to what this chapter, namely burden of proof, right from section 101 up to 140, and now we have 114A, which deals with what? Presumption as to absence of consent in certain prosecution for rape. And it says, in a prosecution for rape under clause small a or clause small b or clause small c or clause small d or clause small e or clause small g of subsection 2 of section 376 of the Indian Penal Code, where sexual intercourse by accused is proved. So what is proved? Sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and she states in her evidence before the court that she did not consent. The court shall presume that she did not consent. So the court will take it for granted there was no consent, otherwise in general, when we talk about criminal liability, burden of proof lies on prosecution to prove the guilt of the accused person beyond reasonable doubt. Here it is must for the prosecution to prove that it was without her consent. But then, as far as section 114A is concerned, this is the change that has taken place. This is the amendment to the Indian Evidence Act, which says the court shall presume that she did not consent. So there was no consent on her part, and in order to, then in that case, for example, in order to prove that it was with her consent, it is the burden of proof is on the accused person accordingly, as per section 114A of the details. As you go on learning the provisions of the Indian Evidence Act, you will understand. But this is presumption as to the absence of consent in certain prosecutions for rape, as far as section 114A is concerned. With this now, the other section, for example, when we deal with the provisions of the Indian Evidence Act, if you read section 146 of the Indian Evidence Act, which deals with questions lawful in cross-examination, and it says, when a witness is cross-examined, he may, in addition to the question herein before referred to, be asked any question which tend to test his veracity, to discover who is he and what is his position in life, or to shake his credit by injuring the character, although the answer to such questions might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to penalty or forfeiture. And the proviso was inserted, we had in the year 2003, which says, provided that in the prosecution for rape, when there is a prosecution for rape or attempt to commit rape, it shall not be permissible, it will not be allowed, it is not permissible to put questions in the cross-examination of the prosecutrix as to her general immoral character. So, provided that in the cross-examination, what is the proviso? Provided that in the prosecution for rape or attempt to commit rape, it shall not be permissible. It will not be allowed by the court of law. It shall does not include shall not. It shall not be permissible to put questions in the cross-examination of the prosecutrix as to her general immoral character. No question regarding her general immoral character can be asked as far as when it's a case of rape or attempt to commit rape accordingly. With this now, if you refer to one more provision, and that is if you refer to section there are some other provisions with which we shall be dealing during course of time, and then this is along with this now, as we proceed further, generally when we talk about the trial is always conducted in open court. But then this is a time for me to draw your attention, because section 300, and this has got I refer to the provisions of the Indian Evidence Act. Now this is section 327, which says court to be open court, and what it says, the place in which any criminal court is held for the purpose of inquiring into or trying any offence shall be deemed to be an open court, to which the public generally may have access, so far as the same can conveniently contain them, provided that the presiding judge or magistrate may, if he thinks fit, order at any stage of any inquiry into or trial of any particular case that a public generally or in a particular person shall not have access to or be or remain in the room or building used by the court. But then the amendment which was carried out in the year 1983, which says subclause 2, notwithstanding anything contained in subsection 1, the inquiry into and the trial of rape or an offence under section 376, section 376A, capital A, 376 capital B, section 376 capital C, or section 376 capital D of the Indian Penal Code shall be conducted in camera. In other words, nobody, the court, it is for the court to ask everybody to go out. Nobody shall be allowed, only the concerned advocates will be allowed to be there. And then the further part says, provided that the presiding judge may, if he thinks fit, or on an application made by either of the parties, allow any particular person to have access to, or be, or remain in the room or building used by the court. Provided further that in-camera trial shall be conducted as far as practicable by a woman judge or magistrate. And thirdly, clause 3, subclause 3 says, where any proceedings are held under subsection 2, it shall not be lawful for any person to print or publish any matter in relation to any such proceeding except with the previous permission of the court. Provided that the ban on printing or publication of trial proceedings in relation to an offence of rape may be lifted, subject to the maintaining confidentiality of name and address of the party. So this is the change that has taken place as far as subclause 2. It's subclause 2 of section 300, and otherwise we say the trial is in general, it is always conducted in open court, but the proceeding shall be conducted here in camera as far as section subclause 2 of section 327 of the Criminal Procedure Code is concerned. With this now, we as we start, during the course of time, we shall be dealing with when we deal with of offence of false evidence and offences against the public justice, right from section 191 onwards. We will come to section, but this is the time for me to draw your attention to section 228A, which was amendment as far as say in the year 1983 is concerned. This is regarding Indian Penal Code, and what it says, disclosure of identity of the victim of certain offences, etc. And it says, subclause 1, whoever prints or publishes the name or any matter which may make known the identity of any person against whom an offence under section 376, section 376A, section 376B, section 376C or section 376D is alleged to have been alleged or found to have been committed, herein after in this section referred to as the victim, shall be punished with imprisonment of either description for term which may extend to 2 years and shall also be liable to fine. Subclause 2 says, nothing in subsection 1 extends to any printing or publication of name or any matter which may make known the identity of the victim if such printing or publication is small a by or under the order in writing of officer in charge of police station or the police officer making the investigation into such offence, acting in good faith for the purpose of such investigation, b by or with the authorization in writing of the victim, or small c where the victim is dead or minor or of unsound mind, by or with the authorization in writing of the next of kin of the victim, provided that no such authorization shall be given by the next of kin to anybody other than the chairman or the secretary by whatever name called of the recognized welfare institution or organization. And for the purpose of this subsection, recognized welfare institution or organization means a social welfare institution or organization recognized in this behalf by the central or the state government as far as the explanation to the section is concerned. Subclause 3 says, whoever prints or publishes any matter in relation to any proceedings before a court which with respect to an offence referred to in subsection 1 without the previous permission of such court shall be punished with imprisonment of either description for term which may extend to 2 years and shall also be liable to fine. And the explanation says the printing or publication of the judgment of any High Court or the Supreme Court does not amount to an offence within the meaning of this section. So this is as far as section 228A of the Indian Penal Code is concerned, which has to be taken into consideration at the time of understanding the provision as far as the law relating to rape is concerned. With this now, this is also the time for me to draw your attention. When you shall be dealing with the provisions of the Criminal Procedure Code, you will come across section 53A of the Criminal Procedure Code. And it deals with what? It deals with, this is as far as the arrest of person is concerned, right from section 41 up to section 60. And this is 53A deals with examination of person accused of rape by a medical practitioner. And it says, when a person is arrested on a charge of committing an offence of rape or an attempt to commit rape, and there are reasonable grounds for believing that an examination of his person will afford evidence as to the commission of such offence, it shall be lawful for registered medical practitioner employed in a hospital run by the government or by local authority, and in the absence of such practitioner, within the radius of 16 kilometers from the place where the offence has been committed by any other registered medical practitioner acting at the request of police officer not below the rank of sub-inspector, and for any person acting in good faith in his aid and under his direction to make such an examination of the arrested person and to use such force as is reasonably necessary for that purpose. Subclause 2 says, the registered medical practitioner conducting such examination shall, without delay, examine such person and prepare a report of his examination giving the following particulars, namely: 1. The name and address of the accused and of the person by whom he was brought, the age of the accused. 3. Marks of injury, if any, on the person of the accused. 4. The description of material taken from the person of the accused for DNA profiling, and 5thly, other material particulars in reasonable detail. Subclause 3 says the report shall state precisely the reasons for each conclusion arrived at. Subclause 4 says the exact time of commencement and completion of the examination shall also be noted in the report. Subclause 5 says the registered medical practitioner shall without delay forward the report to the investigating officer, who shall forward it to the magistrate referred to in subsection 173 as a part of the documents referred to in subclause A of subsection 5 of the section. With this now, if you start reading right from section 154 up to section 176 of the Criminal Procedure Code is concerned, namely information to police and their power to investigate, again, if this is the time for you to deal with an amendment which was brought about in the year 2006, and this is section 164A, as section 53A was an amendment in the year 2006. Similarly, this was 53A just now with which we dealt was an amendment as far as Criminal Procedure Code is concerned in the year 2006, and now this is also section 164A is also an amendment which was in the year 2005, which came into force from in the year 2006, and it says 164A, medical examination of the victim of rape, and it says subclause 1, where during the stage when an offence of committing rape or attempt to commit rape is under investigation, it is proposed to get the person of the woman with whom rape is alleged or attempted to have been committed or attempted examined by a medical expert. Such examination shall be conducted by a registered medical practitioner employed in a hospital run by the government or local authority, and in the absence of such practitioner by any other registered medical practitioner with the consent of such woman or of a person competent to give such consent on her behalf, and such woman shall be sent to such a registered medical practitioner within 24 hours from the time of receiving the information relating to the commission of such offence. Subclause 2 says, the registered medical practitioner to whom such woman is sent shall without delay examine her person and prepare a report of his examination giving the following particulars, namely: 1. The name and address of the woman and of the person by whom she was brought, the age of the woman. 3. The description of material taken from the person of the woman for DNA profiling. 4. Marks of injury, if any, on the person of the woman. 5. General mental condition of the woman. 6. Other material particulars in reasonable detail. Subclause 3 says, the report shall state precisely the reason for each conclusion arrived at. Subclause 4 says, the report shall specifically record that the consent of the woman or of the person competent to give such consent on her behalf to such examination had been obtained. Subclause 5. The exact time of the commencement and the completion of the examination shall also be noted in the report. Subclause 6. The registered medical practitioner shall, without delay, forward the report to the investigating officer, who shall forward it to the magistrate referred to in section 173 as a part of the documents referred to in clause small a of subsection 5 of that section. Subclause 7 says, nothing in this section shall be construed as rendering lawful any examination without the consent of the woman or of any person competent to give such consent on her behalf. And the explanation to the section says, for the purposes of this section, examination and registered medical practitioner shall have the same meaning as in section 53. So that you have reference to section 53 which serves the purpose. So when we are dealing with law relating to rape, this is the time for me to draw your attention that when we shall be dealing with this, once you deal with the law provisions as far as the law relating to rape is concerned, it is not only one section. Yes, what do you mean by rape? For that you can refer to, or you can understand by taking into consideration only section 175, or as is dealt by the provisions of the Indian Penal Code. But along with this, the time for me to make mention, and that is the reason we have dealt in detail in the sense, I have tried to cover all the aspects, the amendments that were brought about in the year 1983, the amendment that was brought about in the year 2006, the amendment accordingly. So in the absence of understanding these amendments, it may not be possible for you to know, and you will understand why these amendments were brought about, because as we have learned that law is an instrument of social change, or what is known as social transformation as far as the provisions are concerned. So this is law. This is law as far as the law as far as the rape is concerned. And with this now, this is the time for me to draw your attention and then to take you to one more section, and that is section 155 of the Indian Evidence Act, which deals with impeaching credit of a witness. And it says the credit of a witness may be impeached in the following ways: by adverse party, or with the consent of the court by the party who calls him. 1. By the evidence of persons who testify that they, from their knowledge of the witness, believe him to be unworthy of credit, or by the proof that the witness has been bribed, or has accepted the offer of bribe, or has received any other corrupt inducement to give his evidence. or by 3. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. And in this section, in the past, we had fourth subsection 4, but this subsection 4 dealt with what? It dealt with when a man is prosecuted for rape or an attempt to ravish, it may be shown that the prosecutress was of generally immoral character. And now today the law, because of the amendment in the year 2003, this subclause 4 of section 155 of the Indian Evidence Act has been omitted. With this now, when a man wanted to commit rape and he is successful, what is the manner in which he can be punished by the court of law is dealt by the sections accordingly. But what happens when a man had intention to commit rape? He had, preparation. He had crossed the stage of preparation and there was what is known as an attempt on his part which was unsuccessful. In order to determine the quantum of the punishment that can be inflicted by the court of law, the punishment is as per section 511 of the Indian Penal Code. So section 511 deals with when there is no express provision for punishment for attempt to commit an offence which is also an offence, then the quantum of the punishment can be determined by taking into consideration or by having reference to section 511 of the Indian Penal Code. With this now, the person wanted to commit rape, he was just undergoing a stage of preparation, and then what is his liability? He has not crossed the stage of preparation. Under such circumstances, such person may be liable for as per section 354 of the Indian Penal Code, which deals with what? It says assault or criminal force to woman with intent to outrage her modesty. And it says whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either discretion for a term which may extend to 2 years or with fine or with both. So this is also to be read with what? First of all, you have to understand the offence of rape. If there is attempt which is not successful, his liability may be for the offence of attempt to commit rape. If he has just undergone a preparation and he has not crossed the stage of preparation, then the punishment may be as per section 354, which deals with criminal force or assault with intent to outrage modesty of a woman. With this, the time for me to draw your attention to one more section, and that is section 509 of the Indian Penal Code. We may deal with this chapter right from section 503 onwards as far as Indian Penal Code is concerned, which deals with criminal intimidation, insult and annoyance, with which we shall be dealing. But this is the time for me to draw your attention to section 509, which says word, gesture or act intended to insult modesty of a woman. And it says whoever intending to insult the modesty of any woman utters any word, makes any sound or gesture, or exhibits any object intending that such word or sound shall be heard, or that such gesture or object shall be seen by such woman, or intrudes upon the privacy of such woman, shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine or with both. That is as far as section 511 is concerned. With this now, the next part, as I have told you, we have dealt with offences against the property, offences against the human body. Now, dealt with offences affecting the human body too. Now the time for me to draw your attention to the chapter, namely general exceptions, right from section 76 up to 106. In order to understand this chapter, the first thing that we shall be dealing, we shall try to understand the importance of this action. Then we will try to club the sections together, so it becomes very easy for us to understand. But that, I mean, with which we will continue as far as next part of our lecture series is concerned.